Alice here with a high conflict child custody video on classes. What I'm specifically talking about is the court sending people to parenting classes or anger management classes or domestic violence classes, maybe drug and recovery classes, addiction recovery classes, stuff like that. I don't know where the courts get this authority from in Nevada. I haven't seen a statute, a rule, anything that expressly allows the courts to send parents to classes. I think they're doing it under the catch-all best interest of the child principles, and because of that, my advice is to just go to the classes. You don't want to put a giant bullseye on your face as the parent who refused to go to classes, because the other parent is going to exploit that and point the finger at you and say, look, they're obstinate, they don't want to go to classes, they don't care about the kids. I went to the classes, I'm a great parent, give me custody. You don't want that to happen. So just grin and bear it, get yourself through the classes. The only two things that I would say as an exception is if you can't afford the class and you can't get the fees waived in some way, and the costs are just so high that it's going to get in the way of you getting groceries or something for the kids, like clothing, stuff like that. You can usually get the fees waived if you can't afford them, and from what I've heard, a lot of the classes are free anyway, at least in Nevada. The second thing I wanted to mention is read what you sign when you go to those classes. Some of them have you sign things that admit to you having committed domestic violence or domestic battery, for example, for that class. Read those carefully, because if you're in court defending yourself, if you're facing allegations of domestic violence and you're defending yourself in court, the last thing you want to do is just quickly sign paperwork without reading it, and then your ex getting hold of it and filing it in court and saying, look, they signed this paper at the domestic violence battery class, and it says right here that they admit to having committed domestic violence. That could happen. So just read them carefully, and if you see something in there that makes you uncomfortable, don't sign it. I've heard of a parent from New Hampshire making a big deal out of it, and the class told him, you know what, you don't even have to sign it, just come to class. I'm not sure if they actually had any problems subsequent to that, but my understanding is that he made a big deal out of that paperwork because he didn't want to admit to it, and they said, okay, fine, just come to the classes, you don't have to admit to it. So just those are the only things that I would really say. If anyone in another state has seen the courts get their authority from somewhere, like a statute or something, post that in the comments below. I'd be interested in taking a look at that. If anyone from another state has successfully beaten having to go to classes, that's another thing to post in the comments below. Let people know how you did that, because I don't think that you can really beat going to the classes in Nevada without risking a custody award, a disfavorable custody award. Oh, one more thing before I go. There was a class that I had to attend because a court ordered it, and the class was no longer being offered. I can't remember any of the details now. The way I took care of that was I filed an affidavit with the court stating I, Alexander Falcone, was ordered to go to this class. I couldn't go because this place no longer offers it. I posted a few extra, or I wrote a few extra details into that affidavit, like the name of the person that I talked to and the number in case the court wanted to contact them. When I filed that, it went away. Nobody bothered me about it, not even my ex's attorney. So yeah, make sure you just dot all your I's, cross all your T's, and file something with the court to just let them know well in advance that you've tried to do this and you can't because of whatever problem arose. That way it doesn't look like just you at the last minute saying, oh, I couldn't go and do this because of X, Y, and Z. It's better to, in my opinion, it was smart for me to file that immediately, because I was worried that next time I went to court 2 or 3 months later, the attorney might say, he's just lying, he's just saying that now because he didn't do it and he doesn't want to look bad. I filed it well in advance and it was just left alone. So that's what I would say for anyone who has been ordered to attend a class that is no longer offered, has been discontinued, something like that. With that, I'm going to go ahead and end this video, and I will see you guys next time.